pronounce yours well, Wepener or Wepener? Wepener.
N-E-R, Justice.
Would you please pronounce it for me?
Wepener.
Wepener. Thank you, sir. You're welcome.
Thank you, Justice.
Judge, you are a judge of the High Court.
Yes, I am.
And you have been a judge of the Electoral Court on a continual basis to date?
I have. It will be 4 years in February. I was appointed in 2013.
Needless to say, you have pronounced on quite recent decisions in Hlope, Kham, and Lota that saw their way to the Constitutional Court.
Yes, Justice.
Judge President, the floor is yours.
Thank you, Chairperson. Judge Wepener, you have been with the Electoral Court for about 3 years now, and you were appointed for a period of 4 years, am I right?
That is so. Judge Shongwe.
Now, I have worked with you for some time. I was in fact appointed in 2014 as chairperson of the Electoral Court. With the amount of work that court receives, is there any comment you want to make on that aspect, on the amount of work?
Mr. Shongwe, there's more work there than I think meets the eye. And fortunately for us, me and Judge Mushidi in Johannesburg, our Judge President allowed us time to deal with the matters, especially in this election year. I'm not talking about by-election years. There we make time. But he, especially after the election, gave us 3 or 4 weeks to concentrate on all these matters. And I don't think the general public out there knows how many matters we actually with. They will see the few reported judgments. I think we gave orders in over 12 matters. No, much more. Case number 016, I recall. So we did a large number of matters, and you were the only one that didn't have time off from your president of the court. We all had time off and could concentrate on it.
Yeah, just to correct you, in fact, it's about 22 matters. That is now in relation to the recent local municipal elections.
You may very well be right. I didn't count, Justice Shogwe.
Well, I'm happy that you are punting my case now, that I should also. Is there any change that you would want to see in the Electoral Court, or you happy in terms of the legislation, the regulations, and the legislation that is in place?
It's a difficult one. There are issues which I specifically addressed in some of the judgments, especially in relation to by-elections and the busing of people, that needs attention. But I think it's something that the Commission, as the custodian of those laws, are entitled to and may take further. We have made the recommendations. Judge Shongwe, it's a specialized court, and I think the appointment of judges to that court is important, and it would be more important to have judges, full-time judges there instead of non-judges. But I'm not saying that as a criticism. I think it is maybe something that can be looked at. It will be more cost efficient because you don't have any cost in relation to the judges to participate unless there's traveling or something like that.
Thank you, Chairperson. I've got no further questions.
Thank you, JP. I recognize you, Mr. Nyambi.
Thank you. What is your view of the South African electoral system in its current form?
Beg your pardon, Mr. Commissioner. Judge President, will you please switch off?
think it works. I think it's important that it dovetails with the Constitution. Um, I think we've just seen a very successful election on local authority level. I have no particular criticism of the system that I find needs urgent or drastic all over.
Do you think is there any need for it to be improved as is? Any need for it to be improved?
Madam Chair, if I may say yes, we have made certain specific recommendations at times in the judgments, but then it's not always for us to make recommendations. It's more for the Commission to take the problem and then to recommend legislation to Parliament. It's not really in our sphere. We can say certain things, but there are certain things that are not within our sphere to give. I believe that the electoral system works pretty successful in this country.
Thank you, Acting Deputy Chief Justice.
Judge, I want to believe that it must be very difficult for judges to pronounce on some issues. For instance, you are talking about busing of people. When we continue to live in two South Africas, for instance, you have an overwhelming number of people living in informal settlements, which are not demarcated, which don't have addresses. And now when a bus comes full of people, even if you can arrest them and say, go and show me where you come from, they wouldn't be able to do so because there's no formal settlements. Don't you think that that makes your life difficult?
Deputy Chief Justice, no, I think the Constitutional Court has now pronounced you don't have to show an address. The Commission must ensure that you live within the area where you registered. It doesn't mean that you've given an address. That has been the case, and I know, and I'm not talking about buses full of people arriving. The term busing in means when there's a by-election, that people unlawfully register in an area where they don't live. And once the Commission gets the address issue, when I say the address issue, let me rather say the living issue, that you are registered there where you live, when that is sorted out, I believe the problem will be at an end. The recommendation made by us in our judgments, whether it's not binding, to the Commission was that when a by-election gets called, not to allow further registrations until the by-election had taken place. Then you cannot have busing in that sense where people unlawfully come and register in wards where they're not supposed to be. That's what I term busing. I didn't mean a busload of people just arriving to vote.
No,
If I may comment,
I'm
Chair, not me. I didn't do that.
no, I'm persuaded that you know what you are talking about. And I thank you.
Thank you, Mr. Commissioner Motshekga. Commissioner Smith?
Thank you, Madam Chair. I see that you wrote the minority judgment in the CAM matter, which was upheld by the Constitutional Court. But my question is more relates to your understanding as to the period of 4 years to which you are appointed. What is your understanding thereof? And second, would you like to make any proposal whether it should be extended or not? The 4-year period, not...
Madam Chair, I'm still going to be in that court for anything that happens until February. It's this body to decide whether I'll be there for the elections in 1919. If they add another, I don't know what the President will do. They'll add 4 years because some of the members there have been appointed for 5 and 6 years. I had 4 years. If I get another 4, I'll be there for the next big election in 1919. Yes. Time has flown.
I think to a certain extent you've answered my question, but it seems to be by virtue of a decision by the president that your term of appointment runs from a number of years?
Yes, indeed. I came for an interview 4 years ago, and I got the certificate that says that's the period. I don't know of any legislation that says what the period is, but that's what I got, whilst other members of the court got 6 years. So it's up to the president to decide. I presume maybe this body recommends the period. I don't know. But if it is another 4 years, as I said, I will be there for the 2019 elections.
Judge Wepener, thank you for making yourself available. The world in general today generally operates according to the system of democracy as we understand it. Maybe some exceptions here and there, and difficulties here and there. Is there any effort on the part of the court to appraise itself of systems elsewhere, challenges elsewhere, positive experiences that the court can draw more and enrich itself from? Or do we generally see our system as unique and therefore tend or try to focus more on the issues at hand and try and contextualize them as we understand the prevailing circumstances in our own specific country? How do we go about enriching the capacity of the court to continue on a constant improvement of its capacity to deal with issues?
Mr. Minister, the only way to do that is by reading. I, perchance, was asked by the president of the court just prior to the elections to attend the signing of the Code of Conduct in the Eastern Cape, and I eventually also attended one in Limpopo, where I gave the keynote speeches, each of those. And I can assure you that prior to doing that, I did a lot of research in relation to voting systems, electoral systems in Africa and in Europe. In fact, I quoted some examples from Asia. So the only way I believe that we can keep abreast and use international knowledge is by reading and doing that which I did in order, as I say, to give these keynote addresses at these signing of the code meetings, if I may call that. So yes, we do learn from international law, and we do take from there what we can in order to promote our own electoral system.
The sense I got to your the answer you gave to the earlier question that was raised I think by Commissioner Nyambi in relation to what your sense or take of our electoral system as it currently pertains is, was the response also in part taking account of those experiences to be able to then say that based on some kind of comparative assessment, you have come to that conclusion, or is there a particular reason why you seem to be, if I understood you correctly, quite positive about our own system in South Africa?
Mr. Minister, if I may confess immediately that the type of matter which we have dealt with locally, as far as I can recall, except that some reference in the majority judgment in the cum matter, in our judgment, not the Constitutional Court judgment, there was reference to some Canadian law. But the type of matter that we have had up to now was in particular, and I can't say all 20 matters, but there were factual matters and there were matters about the interpretation of specific sections in specific circumstances that did not really call for wide application of international principles. And that's why I say that in my experience, we have an adequate and sufficient system that is working.
Sorry, thank you, Acting Deputy Chief Justice.
I recognize Judge President Shongo again. May I just make a follow-up on that point relating to tapping from the jurisprudence of other similar democracies. I'm just thinking that in giving expression to the right to vote in a situation such as that presented itself in the cum matter, I would imagine that the point was, how do you give effect to the scope and nature of that very right in circumstances such as those that presented itself in that particular matter? And I would imagine that it then became necessary to tap from the other jurisdictions.
Deputy Chief Justice, you will recall that those matters which we dealt with, the earlier Lotter matters, all came from by-elections. Those were the difficult areas, and it's in the by-election sense that some new measures may be needed to control the by-elections. So yes, they were very specific in relation to the fact that they were by-elections. And those problems were very specific. I can't recall that any of them called for any specific finding to be made in order to interpret the law based on a general legal principle that may be influenced by jurisprudence from other countries. But it is in the general election, when you have everybody in their own wards and you don't have to worry about busing or whose address is where, that's more when the problem arises. And I must say that in the judgments that I've been involved in, our Constitution has proved to be the saving grace in all those cases, in that it gave the guiding light and the guidance to us to get to the answers which we got to.
Having been involved in these matters where you have to make a pronouncement very quickly, does it, the load of evidence that you are presented with, does it create a challenge to the court?
Deputy Chief Justice, I have to say yes and no. Yes, it's a load of work, but no, it can be dealt with because my judge president allows us the time to deal with the work. So I think that's the full answer. I can't say more than that. If one applies yourself, I think we've dealt with most of the matters within days. No judgment has been outstanding for a long time. In fact, they came out within a week or so, or a couple of days, if not shorter. Most of the times when we sit as a court and we deliberate afterwards and we're all in agreement what the points are, where it should go, we'd give the order immediately, and the judgment may take a bit longer. Parties, if they wish to approach the Constitutional Court, would push us for the judgment, but I think that happened once. Normally the judgments are out because we have the capacity to do that, out in time.
Thank you, sir. Judge President?
Thank you, Chairperson. What I wanted to add was, with regard to the period of 4 years that the candidates have been given, there is no law, there is no rule. I think you are right when you say it is in the discretion of the president as to how long saying that.
I must accept that because there are no prescripts as far as I'm aware, and I mean.
Thank you, Chairperson.
Commissioner Singh?
Thank you very much. Good afternoon, Judge Wepener. You recently gave a very significant judgment with other judges concurring on the exclusion of a political party from participating in the local government elections for reasons which are set out in the papers here. I'm just trying to test my, and you know which matter I'm referring to, and thank you for the judgment. I'm just trying to test my understanding of when an applicant intervenes, what is the understanding when you get a party that intervenes? What is the import of that particular intervention? Thank you.
Madam Chair, I think we would firstly look at the interest that party may have in the matter. He must, if he's got an interest, he's there, and the court will allow intervention like any high court would allow intervention in any matter. It's not particular to the electoral court. In the particular matter you are referring to, sir, we came to the conclusion that it's not necessary to deal with the application for intervention because the party that wanted to intervene wanted to make the same points and would have got to the same conclusion. And in the interest of getting the judgment out, you know that they wanted the judgment, the elections were coming, it was unnecessary to deal with the reasons for intervention or the grounds for intervention because the case ended it like it was, and the intervening party wanted the same result in any event. So it would have been superfluous to deal with that as well on an urgent basis. It may very well have been necessary to deal with it should that matter go to the Constitutional Court and it found against us in the one point, but it would grant the intervention. But that's neither here nor there because in our view, the IFP was making the exact same point that was being made by the other parties in that case.
Note, I didn't mention the party acting Deputy Chief Justice.
I think Advocate Singh, can accept that the commissioners have read the papers and they know who the party is. Thank you, sir. Thank you, Advocate Mutimele. Judge Wepener, let me take this opportunity to thank you. And in the presence of the Judge President, also to congratulate your court for the sterling work that you are doing. I've seen those judgments that come from your court, especially when the pronouncements are made as a matter of extreme urgency. Thank you and congratulations for this opportunity to you by the Commission. In the absence of any comment, you are excused, sir.